So, to go straight to the topic for today, I think it is important for me to begin by saying that the question really is not if my business or my startup would have any case of data breach. That's not the issue. The issue is when it will happen, because it will definitely happen. So the question shouldn't be if my business will have a data breach or if we will experience a data breach. It certainly would come. The question is when. Same thing goes for disputes. The question is not if disputes will arise during the course of my startup. The question has always been when it will arise, because it will definitely arise. So this underscores the importance of today's discussion on properly protecting data and resolving disputes, which I have described as a winning combination for startups. So if you can see the slides, the first page, I have noted that this data protection and dispute resolution are two crucial aspects of running a startup. They can significantly impact the startup's reputation, financial stability, and overall success. So understanding their significance can help startups navigate the legal landscape and protect their own interests. So let's quickly go to data protection, which I believe is actually the topic I kind of appeals to me the most, because of the fact that very few startups and business persons actually pay attention to it. So, like I've stated here, privacy is a human right. We all appreciate that fact that privacy is part of human nature. So it's not a surprise that it is actually recognized as a human right, both by our national laws, regional laws, and international laws. All recognize privacy as a human right. And really, data protection rests on that foundation of privacy. The fact that for those who keep diaries, the content of your diary, I've said it's like it's your data. But the fact that you won't like someone to open your diary, read it without your permission, that is at a very basic level what we mean by data protection. So I would quickly like to share a very brief story. A friend of mine referred me to a client who was upset. She was upset that she went to a business establishment applying for a role there, and the secretary was a guy. And the time she went to apply for that job, the secretary's friend was also there. So she submitted her application letter, did the formalities, and left, hoping for them to maybe call her or maybe not reach out to her, depending on if they found her worthy. But something happened, and the reason why she approached a lawyer, because she was annoyed, was because that secretary shared her phone number with his friend, who was not even a staff of that establishment. Of course, most likely the guy perhaps liked her or something like that, and but the fact that the guy submitted her application letter there, and the secretary of the establishment released her personal data to an outsider, constitute data breach. It's a breach of that person's rights under our Data Protection Act. If you go to the act, you see where certain provisions stipulate that the purpose for submitting a personal data must be strictly complied with. So that act of that secretary releasing her phone number to his friend on its own constituted a data breach, which after she approached us, of course, I wrote a letter to the company attaching the necessary exhibits, evidence of that data breach and all that. Of course, we were willing to take it up from there. I don't know how they managed to plead with her. They begged that he was sorry and all that. Well, I still advise that she should also get a written apology if she want to drop the matter. And they wrote an apology to her to that effect. So this actually boils down to what we might discuss. Okay, I think that's like the fourth or fifth slide. What, as a startup, have you actually asked yourself, what is the policy of my business when it comes to data security? What is the policy of my business when it comes to data security? Because like I've stated here, if you intend to, in slide 2, if you intend to operate a business where you would not require the personal information of anybody for any purpose whatsoever, then you have no business with data protection. But I cannot think of any serious business today that won't require the personal information of people, whether employees, customers, or suppliers. Almost every business today is online. Every business wants to have a mobile app or website and all that. So there's no way, whether you are a service provider or you sell goods, you will definitely need the personal information of people, especially in this our era where almost every business is going online. There's this transition to the online space. You will need the names of people, you need their phone numbers, their house address, and all that in order to either begin, continue, or conclude a business transaction. You'll be needing the personal data of people. So data breach is something that most businesses don't really pay so much attention to. But as a business that not only wants to make profits, but wants to have a reputation of putting your customers' welfare and needs at the forefront, you can't actually ignore this issue of data protection. So while this webinar is going on, I would want us to be asking ourselves, what is actually my policy, the policy of my startup when it has to do with data protection? How do we intend to approach this issue of protecting the data of our employees, our customers, suppliers, and even competitors, as the case may be? So, understanding data protection, well, like I've stated in the slide, Section 65 of the Data Protection Act define what we mean by personal data. It's quite a long definition, and I didn't really see need to bore my readers with that long definition. But I stated there that the important thing to understand is that personal data means any information that can be used to identify a person. It includes the person's name, residential address, phone number, email address, pictures, or even medical records. That's what personal data is. And the Data Protection Act, if you read the preamble, the act is squarely and strictly dedicated to protecting the personal information, the personal data of Nigerians. So, as a startup founder who would, at some point, if you have not even started collecting the personal data of individuals, and for the purpose of the act, those individuals are called data subjects. So I'll be using that term, data subjects. And when I say data subjects, I'm simply referring to your customers, your employees, your suppliers, individuals. Those are data subjects. And you, as a startup founder, collecting the personal information of those persons. The law sees you as a data processor and a data controller. These two things, although they have uh, some differences, but essentially those who collect personal data are data controllers. So you, for the purpose of the act, as a startup founder collecting the personal information of persons, the law sees you as a data controller, and you have certain obligations. You can go to slide 2 now. You have certain obligations under the act. So slide 2 talking about the importance of data protection for startups. Okay, just like I've stated, legal compliance. Customers will release their personal data to you at some point. Employees will release their personal data to you at some point. So the question is, what steps have you taken as a startup founder to protect the data your business would certainly be collecting from customers, employees, and other persons? Does your business have a data protection policy, also called data security policy? Do you know that the law requires every business that controls personal data, okay, of persons, to have a data protection officer? Like I've said, how educated are your employees on data protection matters, which speaks to the example I gave earlier of the secretary, that male secretary that released the phone number of a job applicant. You know, this country, I don't know, fortunately or unfortunately, we have this ability or tendency to forgive quickly. And that is, so a lot of persons get away with so many things by just apologizing and saying sorry. Because if something like this happen in certain countries, I believe that lady won't accept those apologies and she would take the matter to the fullest extent. So that's okay. Okay, John Wokocha. Okay, okay. Can he just mute his mic? Okay. So that's for that. That has ended. But the one of the easiest way as a startup founder to even start protecting data is by regularly employing educating your employees. That's one of like the easiest step, apart from having a policy and other measures which we would see today. One of the easiest steps is regular enlightenment, orientation. Your employees should be aware and conscious of the fact that data today is like the fuel of this digital era. So it's something that they should protect the same way they won't protect the money that belongs to your startup. The same way they protect the goods. For that, we should just take the issue of educating our employees very serious. So another importance of data protection for startups is building trust and competitive advantage. Believe me, any serious client, because these days people are the information is everywhere. People are getting enlightened. Once they see your business is very conscious of protecting their privacy, believe me, you will have a competitive advantage within your own market too. And also another advantage which perhaps I didn't include in this slide is issue of secure funds, which I believe is very important for startups. One of the factors which most investors today would consider before even wanting to invest in your startup and giving you funds is how protected is your startup when it comes to data, because these are issues that would expose your business to certain liabilities, particularly legal liabilities that will have financial consequences. How protected is your business? So at Taskcraft, that's where I work. It's a mobile application where the development is still ongoing. But even at this preliminary stage, we are not actually joking with cyber security, data protection. So many steps have been taken to even we have guys that are testing it, to ensure that okay, how easy is it to penetrate into our system and steal some of our records, because there are websites today. If you go online and check them, there are certain websites that their business is to steal data of individuals and sell it to certain persons. Of course, we know we're in the era of cybercrime and all that. So I need not say much on that. Personal data is like the gold of this era. People are not joking with personal data. When we have Nigeria is one of the countries where cybercrime is so high. So this information are the raw materials which these guys use to do what they do. So you can imagine if your business is the one that really takes the issue of securing the personal information of person seriously, and you, of course, you let your customers know, you let the public know that look at the steps you have taken to ensure that whatever information you give to us would actually be protected. You actually stand a chance to create your mark and your unique identity or unique selling point within your particular market. So we can't joke with the issue of data protection. Okay, I think the next slide, understanding dispute resolution. Understanding dispute resolution. Okay, like I've said, dispute resolution should not actually be your first port of call as a startup founder. It shouldn't be your first port of call. The first thing you should try to ensure is dispute prevention. How can we prevent disputes from occurring even before, to reduce your chances of resolving disputes? It's always better to see how you can prevent it from even occurring in the first place. So, like I said, your business can take proactive steps to prevent disputes. Although these steps do not make the business immune from disputes, but dispute prevention measures, however, they reduce disputes. So, in reality, we can't actually say that we as individuals or as startup founders, our business will be immune from disputes. They would always arise. You can't eliminate that factor. But I've always advised people that taking steps to prevent disputes will reduce your chances of dispute resolution. So examples of dispute prevention measures include having written agreements in place for every business dealing and providing regular training for employees and agents of your startup. So the approach is usually very simple. Just like I asked, what your strategy is when it comes to data protection. What is your policy? So as a business too, you should have a policy when it comes to dispute resolution. And I will give one very quick example. Even while you enter contracts with persons or your customers, your document, the contract document, should always contain a clause that in the event a dispute arises, that a letter should first of all be sent to your company, or an email should be sent to your company, as the case may be. Emails are better now, it's quite quicker. And an email should be sent spelling out the grievances of the client, what happened, the date it happened, circumstances, and perhaps 7 days or 14 days, as the case may be, should be given to your business to resolve that issue before taking it to, for example, a court or somewhere. So the advantage this has is that it helps your business to manage disputes internally before it goes out. And as long as that contract document has been signed by maybe your customer or your supplier, as the case may be, they are they are actually bound to exhaust those internal remedies which they have signed by virtue of signing that contract. They are bound to exhaust it before taking it outside. So what you have seen is situations where some persons, once a dispute arises, maybe uh, they go to straight to court or straight to the police. Although but that would still depend on the facts of the case. But you can't uh, say you're doing dispute resolution when a criminal charge is involved. So those dispute resolution clauses do not cover criminal offenses. Once a crime has been committed, everybody has the right to report to the police. But when it comes to civil disputes, this person said he will deliver by this time, he has not delivered by this time. This person said he will pay me by this time, he has not paid me by this time. All those are civil disputes that you can, as a startup founder, ensure by creating a dispute resolution policy, you can ensure that those disputes would be treated internally first before it goes outside, because there are several uh, forums where a customer can actually report to once civil dispute arise. Everybody need not go to court. There's what we call the Federal Competition and Consumer Protection Commission. So this is like it's a statutory body where consumers, and when I say consumers, it's not just those who are buying goods, even those who are paying for service are also consumers by virtue of that law. Most persons do not know that you can actually report a business to the Federal Competition and Consumer Protection Commission, that is the FCCPC, and it would actually expose that uh, startup to certain, well, investigative measures or criminal measures, which you might not want. But if you have a dispute resolution policy and someone goes straight to report to the FCCPC, a simple reply could be that by virtue of our contract or by virtue of our agreement, this person was required to bring this issue internally for us to see how we can resolve it before going out. So at that point, the FCCPC would definitely have to give certain weight or validity to that agreement and allow you guys to see how you can explore disputes internally before it goes outside. So most of these clauses give you as a startup founder the opportunity to manage certain disputes internally before it goes outside. So that is why, as a startup founder, it's very important to have a dispute resolution policy in place before you start dealing with people outside. So, like I've said here, it is impossible to ignore disputes. It is desirable, but it's not always possible to prevent them. This is where dispute resolution comes in. Dispute resolution is all about finding a way to resolve a problem or disagreement. Next slide. So, okay, there are common dispute resolution methods. Essentially, there are a lot of dispute resolution methods, but the, the main four, we have negotiation, which as the name implies, it's about the two persons who are having an issue to sit right between themselves or in the presence of their lawyers to see how they can resolve that. So after that, you have the mediation, which is a neutral third party facilitating the resolution process. Of course, we have the litigation, which we all know, filing suits, going to court, and all that. So we also have arbitration, which is like a process that is in the middle of mediation and litigation. All this can actually be the advantages and disadvantages of each method. Of course, there are, I've summarized them. I won't want to spend so much time there. We can look it up. But the point to make, the point to emphasize is your business should have a dispute resolution policy, and drawing up the policy will depend on the type of business you do, will depend on several other factors, but a policy should be in place so that you can actually manage disputes before they go outside. So the importance of dispute resolution for startups, of course, public relations. It helps manage public relations with your customers, your suppliers, even your employees, and saves time and cost. Saves time and cost. But the issue of your reputation, so which also has something to do with public relations, is something that you should not joke with. Factors to consider when choosing, okay, this resolution option. Well, like I've said, the legal practitioner should always be consulted to evaluate the facts and advise on the dispute resolution method to adopt, because you can't just you can't make general rules when it comes to the option to utilize. It will depend on the nature of your business, really. So always ensure that a legal practitioner is consulted so we can draw up a dispute resolution policy that would work uh, better for your business structure. So the next slide, okay, conclusion. I've summarized some best practices. Some best practices. Number one, having comprehensive policies. Your startup should have a comprehensive data protection policy and a comprehensive dispute resolution policy to see how you can manage these issues before they go out of hand. So the second one, regular updates. And this is very important for startups that run via mobile applications. Although everybody really should regularly update his policy, but this is particularly important for those startups that have or they operate via mobile application. Regular updates very important to keep up with the changing nature of the legal framework. So robust security measures, yeah. Implement robust security measures to protect data. This you can't really overemphasize this point. Then you have strong stakeholder relationship to maintain good relationship with stakeholders and always have written versions of all business activities and dealings to prevent dispute. This is and the most painful part is that this is so easy. It takes nothing for me. It takes nothing to always reduce everything to writing. It really takes nothing. You don't. Everyone has a phone. You have a laptop. I see no reason why people should be doing things orally in this data. The particular case I'm handling, and one of the reasons why is giving my team and I unnecessary headache because almost everything was done orally. Almost everything was done orally. So it makes our work as lawyers even more difficult. It's of course now, and you will spend more as a business owner or an entrepreneur. You tend to spend more. It takes nothing to even something as little as having a meeting with persons. Where I work as data protection officer, our meetings we always take down minutes of meetings, and even when you're having this kind of meeting, like a virtual meeting, there are I think, AI tools that you can use to record, transcribe meeting. Everything just needs to be in writing. It makes the whole work easy for everyone. It makes the whole work easy for everyone. Strong stakeholder relationship. Okay, I've talked about that. Employee training too. Whether I like to know, these guys are your agents. And the law is that what an agent does, it is him that the principal himself is doing it. So your employees are your representatives. So no matter how educated you are, once those guys are not properly trained, you're exposing yourself. You're exposing yourself. So you can't overlook the importance of regularly training your employees. Of course, dedicated professionals too. Your startup should have a data protection officer, a legal advisor. This would make the whole, you have actually transferred so much burden, so much workload, so very little thing to worry about. Let that department know that, okay, this is our job to make sure that everything is in writing, to know what to write, know what not to write. Of course, with your interests in mind. So having a dedicated department to handle issues like this is something that one needs to also take very, very serious. These are best practices which would ensure sustainability of your startup. So the next slide, like I've said, data protection and dispute resolution, a winning combination. So by prioritizing data protection and having a robust dispute resolution strategy, startups can build a strong foundation for success. And this approach fosters trust with customers, protects the business from legal risks, and ultimately contributes to a positive and sustainable growth trajectory. So the last slide, which are the key takeaways. Data protection is crucial. Data protection is essentially for building trust, complying with regulations, and protecting your startup from legal risks. Dispute resolution is key. Having a well-defined dispute resolution strategy can help you manage conflicts effectively and minimize potential damage to your business. Investing in expertise. partner with legal professionals, data protection experts, and it even goes beyond this too. Accountants, these are persons whose, by virtue of their training too, by virtue of their training, they are in a better position to guide you on how to go around legal compliance. Because believe me, the the cost of non-compliance, there's this saying that if you think education is expensive, try ignorance. But I'll change that. If you think compliance is expensive, then just don't pray to know the cost of non-compliance, because believe me, something that you won't want to go through, especially if you are stepped on the toes of someone who you just pray not to step on their toes. Because believe me, some persons do not take breach of their rights or their interests lightly. So, like I've said, finally, is by prioritizing both data protection and dispute resolution, startups can create a strong foundation for success and achieve their goals. Uh, so, with this, I've come to the end of this very, very brief webinar.
We just want to open the floor for questions. If you have any questions, if there's anything that was spoken about that wasn't too clear to you, you can just let us know in the chat segment. Um, awesome. So Michael Ola says, my business operates with grassroots individuals that are careless about legal structures and applications, like village farmers, traders, and suppliers. How important are privacy policies to our work? And what are the implications if this is not applied over time?
Okay, so and the way I understood that question is essentially saying that these persons are more or less not so informed as to their rights when it has to do with privacy issues and all that. And of course, this speaks to the general issue of, I say, illiteracy or lack of information within our country here. So that the fact that some of them might not be aware really shouldn't preclude a business from taking these issues serious and actually complying on their own part to these requirements. It shouldn't preclude you from doing that, even if these persons are, are not aware. Because one thing I've also come to realize within the short period I've been in this practice is that we can't really foresee the manifest set of facts, events which will arise tomorrow. We can't actually foresee the events that will apply tomorrow, that will unfold tomorrow. Let's say, like in my village community, they'll say HED, which is tomorrow is pregnant. You don't know what will come. So, and another thing too, another area which I would like to emphasize is that when it comes to convincing investors, those who want to perhaps invest in your business or give you loans and all that, essentially funding. So when it comes to funding, one of the ways to convince investors and outsiders that we are serious. We mean business. But once your application or your proposal is before a group of investors, and I'm also, although I'm aware that most tech startups, there's usually this tech fair they do where startup founders send their proposals for investments, and I would love to also believe that that also applies to the agro business too, something like a fair or scheme where those in this your line of business would be required to submit maybe proposals for funding and all that. Once a group of enlightened, because now your you're not dealing with your customers who perhaps are uninformed. Once your proposal is before them and they look at it and they see that, oh, these persons are even averting their minds to issues that concern privacy, it gives this, it sends a message of these persons are serious with their business, these persons are thinking long term, these persons know the value of sustainability. So generally, your reputation as a business owner is enhanced. Your likelihood of obtaining fund is also enhanced. So it would even be that you even take it as part of your corporate social responsibility to even educate those farmers. Although, uh, depending on the type of person is there, because I will know that most of, especially if they are very, very advanced in terms of age, they might not really want to take issues of privacy so serious. But for you as a business and also for someone who might be looking for funds tomorrow and partners too, you would want to, believe me, you want to pass that message that yes, I'm thinking long term, I'm thinking sustainability, and how do you show that you are thinking long term and you value sustainability is by addressing issues like this. It adds more uh, for you as a business owner. It makes you look more serious, really. Thank you. Yeah,
Wonderful. Thank
I
you so
think.
much. Um, Another question from Uma Issa Suleiman says, I was recently called by a loan app in respect to a startup who collected a loan from them and amongst their contact. Let me take that again. I was recently called by a loan app in respect to a startup who collected a loan from them and among their contacts. Is that a breach of privacy, and whom should sue? I hope that question
Okay.
is clear.
Yes. Actually, the head, is it called chairman or director general? I can't remember the appellation they gave to him, but the head of the both NCC and the FCCPC, they conducted an interview on national television on this same issue. And, it's something that's becoming a nuisance. Something that's becoming a nuisance. Where persons who are not even aware, they were not consulted before they were made, well, let's say, guarantors or sureties to loans. And you see them essentially harassing persons. So it's an issue that has become more or less even a national concern too. And if you receive such a message again, I think the first thing you should do is to, on your part, require the the contract information, the documents, the details of both the loan app and the transaction and everything. because most times they call without giving you their details and all that. Once you are able to get the details of these persons, then both the guy or your contact, the person that gave your contact to them, and they themselves, they would be, of course, you have to join both of them if you are to take legal actions against them. But first of all, get the details of the company and all that. And you can begin by also writing a strong ordered letter to them, telling them this is what you would do if the harassment continues. But yes, to answer your question, it is actually a breach of your privacy rights under the data protection law for you not to even be consulted before you have made a surety or guarantor to a, a business transaction. And really, your primary thought result, what I mean by thought result is the person who harmed you primarily is the person who gave your contacts to them to serve as you know, a surety or a guarantor to that particular transactions. Definitely, it's a legal wrong, and there are remedies to address that. There are steps to also address that, but needless to say that you really do not owe them any contractual obligations to pay that amount. And I really don't know how those persons structure their business such a way that the person you are making a surety or a guarantor is not even aware his consent was not obtained and you just made him. So the FCCPC is actually going after those companies. They are going after them. They are going after them. NCC, they are also going after those persons, at least from the heads of those agencies. That's what we're told. They are going after those persons, but you definitely do not have any contractual obligations to them, and you can definitely take legal actions, even if not under the Data Protection Act, but there are other remedies under aspects of law, such as torts, that you can explore to get a remedy. So I hope that answers that question.
So David Musa asks, are there differences between various policy laws in Nigeria compared to international regulations? And when we are dealing with customers from international demographies, how do we stay compliant? And which laws liable of being, or which laws are liable of being breached? I mean, which laws
Okay,
concerning us, Nigerian laws or international laws?
okay.
He
Thank
also
you.
asks, he also asks as a follow-up, he says, how can we ensure that consent given for data usage remains valid over time, especially if we change how we handle data? That's two questions.
Okay, okay. Let me answer the first one. Now, of course, we are in an era where national boundaries are being made slimmer and slimmer by the day as a result of internet technology and all that. So international trade, international transactions is something that we cannot really, we can't avoid. It's inevitable. We'll definitely have interactions with persons from other countries. So with specific reference to issue of data protection, yes, there are international laws which we might describe as soft laws. They're called soft laws. They're called soft laws because more or less systems to enforce them are not really, they're really absent. They just create a general framework for the international community to use. And the various countries which make up the international community are always urged to domesticate these laws. At best, at best, it's in forums such as maybe International Court of Justice or the ECOWAS Court or African Union Court that, although those ones really are quite rare, but there are regional laws that are applicable within the African continent on data protection. The international laws applicable as put forward by the United Nations. But these laws just create a general framework. They just draw up general principles. And if you go through our data protection law in Nigeria here, it's more or less like we have embraced those international laws and we have domesticated them. So now you won't see substantial difference between the Nigerian Data Protection Act and, for example, the regional law on data protection. But when it comes to governing law, which law will govern a particular transaction, that is for the parties to decide. So this is where the legal practitioners will come in, and in reality, this is where bargaining power comes in. So in a particular contractual transaction, you will definitely know who has the upper hand. Because if you have the upper hand in a particular business transaction, you would most likely provide that the governing law for this particular transaction is, for example, Nigeria. If Nigerian law, if you have the upper hand, it boils down to negotiation. But international transactions generally make provisions for governing law. So it's from that contractual transaction that we will know the law governing that particular issue and the seat. The seat of resolving disputes. If you remember clearly, some persons were asking during this PI and D issue, why did, even if those facilities were built in Nigeria, why did we take the dispute to UK to resolve? Simply because the governing law, the contract which was prepared for that particular transaction, it was stipulated there that the governing law here shall be laws of this country and the seat of dispute resolution will be in this country. So that is for that. The issue of governing law, which particular law will govern this transaction, is for the parties to decide. In reality, in practice, it's the person that has the upper hand most times that would insist that if you want me to do business with you, this particular transaction will be governed by this particular law. That one is on its own part. And I think this second question is, I can't remember. Can you just help me? That's the second question.
The second question was, how can we ensure that consent given for data usage remains valid over time, especially if we change how we handle data?
Yeah. This issue has actually been addressed by the Nigerian Data Protection Act, whose provisions are similar to the regional law on data protection and the international law on data protection. So the law is quite straightforward. Consent can always be withdrawn at any point in time. It is the law. Consent for data processing and data usage and data retention can always be withdrawn at any point in time. And the law requires a data controller or a data processor, as the case may be, to ensure that the procedures for withdrawing consent is as easy as the procedures for giving consent. So it is a breach of the data rights of a particular data subject to say that you can't even draft such a clause in your data protection policy that they cannot withdraw consent, because that will be against the Data Protection Act. So that one is not even, it's a law that data subjects are entitled to withdraw consent from data processing, data usage, data retention at any point in time. So I hope that answers that question. People are free to withdraw their consent from data usage. They are right.
Beautiful. Just a minute. Michael Ola says, thank you for this session. It has been quite insightful, and thanks for all the answers provided. It says, are there legal documents that startups should have in place regarding data privacy?
Okay. Yes. To answer that question quite directly, there are documents that startups should have, but which documents they should have will really depend on the nature of the business. But generally speaking, generally speaking, a data protection policy is one document you should have. No, when we say policy, policy is this is our direction, this is our approach to this. So even those who your employees, your customers, this is should, if you have a website, for example, for a business or a mobile app, these are uh, more or less provisions or documents that you can even provide a particular section in your website for them to even download it and read. That's your data protection policy. This is how we tend to approach data, this thing, and those intending to deal with you. In addition to every other document which would be necessary to execute for that particular transactions, they should be required to sign that they agree to this, your policy, your approach to data protection. That would give you more or less like kind of a shield that this person saw, they saw how this business has decided to approach the issue of data protection and all that, and they agree to it. You know, most times, most of these mobile apps which we download, most times do not even bother to read those privacy policies and all that. Many of these apps, Bolt, Canva, many mobile applications, they all have data protection policies that, of course, have been drafted in line with the relevant laws in that country and in line with their business interests. Because one thing most people do is just to maybe copy and paste data protection policies, and uh, we know the risks that that one uh, comes with. But the data protection policy is one document that you should have, and this would definitely be prepared in line with the applicable laws and in line with your business interests too. So that's it. But there could be more. I won't know that except the specific details of that business, specific facts have been reviewed and I've gone through them. So I hope that answers that question.
Okay, so we just have about two more questions to go. But before we go, I just want to say that in line with drafting legal documents and your data protection policy and whatever contracts that you might have to draft between yourself, your employees, your clients, your suppliers, or your partners, um, RamenLegal provides a full library of different templates that you can easily draft these documents with. Now, the beautiful thing about RamenLegal is that it's using AI to draft these contracts. And so it's able to learn exactly what your business is about and also draft it based on actual information that has access to. So we've trained the AI basically with different data sets on law, for example, from Nigeria and from different jurisdictions. And so when it's drafting your contracts, it's making references to those laws so that your contracts and your policies and documents are fully compliant. Okay, so you can go straight to the link that we sent to your email. Now, it's important that I've not posted a link on the chat yet because we have people coming in from different communities. And so we have a specific link for those of you coming from the ROWE or the Young Entrepreneurship Empowerment Program. We have a specific link for you, okay, with a very specific layout for you. So make sure to go to the email that we sent out to you and sign up from there. Okay. Of course, shortly after we take all the questions, I will just give you a short demonstration of how easy it is to use the platform. And as you can see, that's what we are sharing. The interface is what we are sharing on the presentation right now. Okay. So I think I'll just take these two questions together because one of them is more broad. Mr. Emmanuel Arobonlo, I hope I'm saying that right. Please forgive me. He says, Sir, how can I upgrade my business in line with data protection? So I think that's a much broader question. And then Mr. Stephen Hua says, Big Step Africa, I believe that's the name of his business. He says, Big Step Africa will run an event ticketing app and expanding to full hospitality. We collect data, and those data help us in sending bulk SMS when we have other events. Is that legal to collect data and send SMS without information or without informing the owners of the data? Does that make sense?
Yeah. I think I understand the question.
Okay.
Yeah, let me answer the second one first about sending bulk SMS. Really, there's as long as now I don't know how your business has been structured. I don't know if at the point of collection you inform them that there's a possibility that you might be sending emails or SMS to you. There's a way these clauses are drafted. Most times it comes in form of bullet points, really. You consent to your business sending you emails regularly, our newsletter, bulk SMS, all those. Usually, people don't even bother to read all those things. They will just sign. But there should actually be a clause. There should be a clause stating that you will consent to the business sending bulk SMS or emails to you to inform you of our new updates or whatever in line with your business interests. So as long as you have obtained consent, because the guiding principle really when it comes to privacy is consent. There's no harm that has been done to anybody that has consented. As long as you have consented to something, there's no harm that has been done to you. So I think to answer that question, Mr. Civil need to ask himself if his company obtained consent from their customers, specifically not just giving you uh, their data, but specifically consenting to the use of that data for that particular purpose. There's something that the organizers of RamenLegal did that I really love. After they took my LinkedIn profile, he actually reached out to me and told me that we are going to attach a link, something like that, to the emails being sent to them. He told me something like that, and although if they had attached it without informing me or seeking consent, of course I won't have done anything. But it was nice to see that these persons are actually complying with all these regulations, and it really gives the that coloration of a very serious and well-informed group of individuals that are running this particular organization. And the point to make is that this data protection issue doesn't just govern businesses that are for profit, even non-profit organizations. So for whatever purpose, data processing is data processing. So I mean, it's the issue of consent is not something you should joke with. That's just a simple answer I can give to that question. They should ensure that they specifically consent to that data being used for that purpose. And the first one, say, how can I upgrade my business in line with data protection laws? Wow, that's quite a broad question. How do you upgrade your business in line with data protection law? And while it's quite difficult to say is that I don't even know the nature of the business, because this thing really, legal advice or expert advice really depends more on facts than even the law, because it's not the law that determines the facts determine the law. So let me see if I can also give a general answer to that. How do I upgrade my business in line with data protection law? I'm begin by, first and foremost, having a data protection officer who would now look at the entire business and see how fast or how well he can streamline your business in line with the data protection laws. Because I really cannot say much on this now, because the facts I'm totally not in possession of the facts that I can use to give any legal advice. But if there's someone there who can look at everything and say, okay, this is where we are, this is where we should go, I think that should be the first step, really. Thank you.